Yeah, it works.
But it is coming here, because I'm white. Is that it?
Oh, it's so dry. Ah, ukwazi zoqala.
Uthi manje uzoqala ngoba. Yeah.
Ungabaleki.
Saqala imini yonke nalo.
Yeah, uyaqoqa nje.
Ah. Ufuna ukushada.
Hayi. Awuzokwazi.
Eke uchizi ibheke yami ninovela. Anginanzi kanye njengoba
Ngasebenzi la.
Aysebenzi?
Yena wakusebenza la ada the extension.
Hey, the extension.
Nangisebenza lo extension.
Ingalungile.
And is your game proceeding at 3? Is your game proceeding at 3? Yeah. And when are they going to play? I need today.
Hey, seven, go. Go.
I said, emotional all the time. Leia,
Nanso ngiyathi phela nani. Le cabasa uzohamba emhlabeni ngathi. Ayikudeni.
amahamba ningagida abanye abantu.
Nasuke endleleni.
Hayibo.
Mahambe balagida abanye abantu.
Awuhamba uyagila. Ohamba uyagila. Ndizothi ndifakela abakazi abadinga nditsho le nto etsho ngumkhulu ufake ibhilede yakhe. for us.
Yes, I make the following ruling. I am satisfied that the point in limine on jurisdiction must be dismissed of course. Mr. Mabaso, now that I have jurisdiction to entertain the matter, would you still pursue the point on non-joinder?
My instructions are to pursue
Proceed.
as it pleases the court. My lord, as we all know, the basis of the application before you today is the root, the underlying issue is the continuation of the national playoffs which are currently taking place in Gauteng.
Before you proceed, I am not the judge that issued the directive. I know, other than the people listed as respondents, at least in both cases, I do not expect that anyone else would have been served the papers. But just for us to be working from the same page, I wish to establish both from Mr. Bobi and Mr. Sikoti that no one else other than the people cited as respondents in their respective notices of motion has been served with papers. Let's just give them that chance.
As a
You get the point?
may
Yes, I'm saying other than the people cited as respondents in their respective notices of motion, in your case it would be 3011.
Yes,
No one else has been served the application.
yes, ma'am.
I've not seen any returns of services, so
Yes, ma'am.
I'm just clarifying.
Yes, ma'am. In
It's a
fact,
factual inquiry.
yes, ma'am. In fact, all the respondents that are cited in our application are before court.
In the matter held by Bloom J, right at the beginning, this was an issue.
Yes,
You
ma'am.
say Amavarara served and are in court.
Yes, ma'am. But they are not part of the proceedings because they did not enter any appearance.
On what basis are you saying they are in court?
Because there is someone from Amawara.
There is a representative of Amavarara.
Yes, ma'am.
Would I be correct to say club official?
I think that's the best way to use it.
I'm sorry, just
Lastly, the fifth respondent, which is Mr. Scott, they are also in court. So all the parties were served. As of
Yes, Mr. Scott. In fact, to be honest with you, the reason I am raising this before even Mr. Mabaso addresses us, you will recall that on the 25th of June when I first became involved in this matter and I read the order that had been issued by Bloom J on 22nd June, Ms. Chabuse took strong issue when it was said the representatives who had played in the finals in Makanda at Rhodes University were before Bloom J said, no, that is not correct. And I had said, no, let's not get into that. I wasn't there. I just want your confirmation on your case, 3011. Has everyone of the respondents been served in that case? Is everyone in court, or have you served anyone else other than your respondent?
Yes. My Lord, we've served all the respective parties. And instead, what we did in our case in respect of the parties who were not before court, at paragraph 13, and I think the respondent deals with this.
Paragraph?
At page 13 instead
Page
of our bundle.
Page 13.
Page 13, which is the notice of motion.
Yes.
And right at the end, what we did instead, as the applicant in that case, we've served all the respective teams via, or rather in the care of Safa. I understand, my Lord, I don't want to dwell much on this because it is taken as a point to be argued by the respondents, but that is what we did. Citing the rest of the participating teams under or in the care of South African Football Association. The details of those people were not known to us when this application was brought. I'm saying so much because we would understand that some of the teams at that time were kicked out by reason of losing the matches and others were still in place. But that is information that is not available for us at the time of crafting the papers. Unlike the position in Sinenkani where they were not cited at all.
Yeah.
Yes.
Mr. Mabaso, solely on a factual basis, you confirm the factual submissions made. Let's put aside whether it's correct or incorrect, it's irregular or irregular. I just want us on a factual basis.
The issue of service of the papers on the cited respondents.
Yes, in both matters, in Mr. Vobi's matter 3011, in Mr. Scotty's matter 3013.
In respect of 3011, firstly, my Lord, my understanding is that all of the cited respondents were served and are aware of these proceedings.
Okay.
I can take it a step further and say, and confirm what Mr. Vobi said, that service in regard to the first and the fifth respondent.
To the first and the fifth.
First to fifth.
Or the Safa.
Respondents, Sinenkani and Amavarara. The Safa respondents, including Sinenkani and Amavarara.
Yeah. And the fact that they may have served the teams in the playoffs care of Safa, that is those you represent. In fact, that has happened. I'm not saying it's the correct thing to do or incorrect. It has in fact happened. Those you represent have received papers purportedly being a service on the playoff teams.
To the extent that
we were served with the papers. I've just confirmed with my
Yes.
attorney. They received one email saying, here are the papers. And then the papers, when you look at the papers then tell you that they were purportedly serving Safa correspondent and serving Safa as a post box apparently for.
What Mr. Scotty pointed me to
Yes.
on
and-
page 13.
Yes, yes, my lord. And correctly, I agree with Mr. Scotty. It's a disputed point, which we have raised.
No, we will deal with it at the appropriate time. You will deal with it.
As a court.
I just wanted to establish the facts because, as you are well aware, because your attorney was quite instrumental in assisting the court to try and get all the papers. I was receiving the papers in drips and drabs, and I don't have any returns of service before. That being the case, we're all on the same page. You may proceed with the non-joinder.
As a court, please, my lord. I confirm my attorney can be useful at times.
Not always.
Not when it comes to payment. My lord, this is a matter that seeks to, amongst other things, interdict the ABC Municipal League playoffs which are currently happening in Gauteng. Originally, 19 were intended to participate in the playoffs. These are the respective winners from the various provinces. As it would happen because of litigation here in the Eastern Cape and in Limpopo, only 7 teams reported, let's call it for duty, when the playoffs commenced. The guys in Limpopo were busy with litigation, and as your lordship knows, everyone in this room, bar myself, was busy with you in separate litigation. My lord, we've taken the point of non-joinder and we submit that it is fatal to both the applications of Sinenkani and Ravens. And I'll demonstrate to your lordship that the case of Ravens is far worse than that of Sinenkani, because they, in their conduct, and I will get to it, just making this point in passing, in their conduct, they demonstrate awareness that they ought to have joined the 7 participating teams. My lord, I think the case for non-joinder is best illustrated by reference to the papers of Kakamas Juventus, whose bundle I understand is before you. However, it's not in the paginated bundle, it's a standalone bundle.
Yeah.
The papers of Kakamas, my lord, are quite helpful on this point. Because they tell your lordship certain things and I'll firstly, I'll wait for your lordship to get there.
Sorry, please bear with me. Yes.
As the court pleases, my lord. Before I go into the papers, it's probably best that I make an attempt to explain the structure of the various football leagues in South Africa.
Has that not been done somewhere? Is
My-
it Mr. Mutante who does that?
Because we are here, my lord, maybe we should just stick with Kakamas, because they give us a great exposition and they explain how it works.
This is on the Kakamas papers, affidavit, page 5, paragraph 25.
Indeed,
Is
madam.
that what you are referring to?
Yes.
Betway Premiership, 2, the Motsepe National First Division, 3, the ABC Motsepe League,
Yes, my lord.
4, the Hollywood Bats Regional League.
That is correct, ma'am. That is the board structure. What these parties, what these clubs in this court and those that are busy playing now in Gauteng, they are the third tier, they are in the third tier, the ABC Municipal League, which is referred to in paragraph 25.3. And they are aiming to go into the second tier of South African football, which is the Motsepe National First Division. That's not the correct name, but it's commonly referred to as the NFD. We can all accept that. The two
You
top
say ABC Motsepe League is not the correct name.
it for the second tier, as I understand it, it's called the Motsepe Foundation Championship. Colloquially, the National First Division, and I think we can all accept that that's what it's called.
Yes.
This one. So, the teams here are trying to get into the NFD, which is the tier above where they are currently competing. The teams, my lord, who are currently competing in the playoffs are listed at paragraph 34 of the Kakamas founding affidavit. Well, he tells us what it does really tells us how the groups were comprised for the playoffs.
Mm-hmm.
So it cannot be disputed that there are 7 teams who are currently playing in those playoffs.
But this lists 7. This lists 3, 6, 9, 34.
No, pardon me, Mano, what 34 does, it tells you how the groups were comprised
Yes.
for the playoffs. Who was going to go where, and they list them in provinces. And suppose, just to get to my point, it's simply to say that there are 7 teams that are there. There were meant to be 9, but the representative from this province is not there, for amongst other reasons, all the litigation that's ongoing, and it's a similar situation in Limpopo. So those 2 provinces are not represented. At some point, well, on the 1st of July, my client's competition committee takes the decision that Limpopo and Eastern Cape will be excluded from participating in the playoffs. That's just by way of factual background to ground why this happened. And then now we have this litigation before you. We take this point of joinder, my lord, because we say those 7 teams which have not been cited in these proceedings have a direct and substantial interest in this matter.
I'm sorry to interrupt. I want us to, because this is troubling my mind as you speak, shouldn't we be speaking of 5 teams now?
Because 2 have come.
Kakamas is
Yes.
here,
Yes.
Mr. Mhlanti is also here.
That's my mistake, my lord. And in fact, the presence of Mr. Dlamini and Mr. Mhlanti in this court. The fact that they come to court and sought leave to intervene and participate in the proceedings demonstrates the direct and substantial interest of all the teams who were participating in these playoffs. And my lord, the point, that same point, is made by Kakamas itself in its founding affidavit. The point about the decision taken by Safa to exclude Limpopo and the Eastern Cape, affecting all other participants, is made even by Kakamas in their founding affidavit. Paragraph 50, my lord. Kakamas says, the first respondent made a decision which directly and materially impacts 1, Kakamas Juventus, 2, the other participants of football and playoffs. So they are referring to the other teams. And 3, the integrity of the sport. My lord, the test for joinder is well known and the principle is tried. The test for joinder is whether or not a party has a direct and substantial interest in the subject matter of the action. The subject matter of the action is to declare the decision by my clients, by Safa, to order that the playoffs can continue. And flowing from that, an interdict to stop the playoffs is also sought. What my lord then must ask is whether an order to that effect will affect the parties that we say were not joined and ought to have been joined. In other words, will the order of this court affect the other teams? If the answer is yes, then those teams ought to have been joined to these proceedings. Because we know that so let me just take a step back. Our point on joinder is in relation, 1, to the non-joinder of the other participating teams, and 2, the non-joinder of the National First Division. The National First Division, and this is also dealt with quite helpfully in the papers of Kakamas, the National First Division is a special member of Safa. And this is explained to us at paragraph 20 of the Kakamas papers, where they say the special member being the National Soccer League. Sorry, not the National First Division, the National Soccer League, the NSL, which is comprised of the Premier Division. All professional football clubs in South Africa are affiliated to the NSL. So the NSL is the body that controls the second tier of South African football, which is the league that the eventual winner of the current playoffs will go into.
It says here the Premier Division, and if I understand you correctly, it's the Premier Division and the NFD.
The Premier Division comprises of 2 leagues.
Oh.
It's what we know as the Premier Soccer League, the PSL, and the second tier being the NFD. Those two leagues or competitions are controlled by the NSL. For that reason, my lord, we say that even the NSL itself ought to have been joined in these proceedings. What is their direct and substantial interest? Or put differently, how would the relief sought by the applicants affect them? Well, we say that because they control the second tier of football, any delay which may be occasioned by an interdict, any delay of the finalization of these playoffs, these disputed playoffs, will affect or has the imminent potential to affect the start of the NFD, because as I understand, 3 teams from the NFD will go, from the ABC Motsete League, will go up to the NFD.
Out of the 9, ideally, if everyone was there, 3 of those 9 would be promoted to the NFD.
3 of those 9 would be promoted to the NFD, which is scheduled to start on the 22nd of August. For that reason, my lord, we submit that even the NFD, in addition to the 5 teams that aren't here, the NFD also ought to have been cited, because it's plainly got a direct and substantial interest in these proceedings. Now, in reply, or to rebuff this point, the gist of Sinenkani's argument is that no, those 5 teams will not be, those 5 teams were not required to be cited because consequent to the relief which they seek, they will still play the playoffs. So what they are saying is, well, it doesn't matter. Those guys will still be. However, Lord, that does not take into account the prejudice that these teams may suffer in the interim. They are there already, they are playing their games, they've incurred whatever costs that they've incurred to go there. On the Sinenkani approach, they must go back home, wait for the litigation or whatever to conclude, incur further costs, come back, or go to whatever neutral venue is decided upon, and play. So the way Sinenkani is looking at the issue of direct and substantial interest is quite narrow. In fact, it's focused purely on them, on what they want themselves. So they're not having regard to the other parties.
If I understand you correctly, what you are now raising is if Sinenkani and FC Ravens were to be successful, there is a potential prejudice to the 5 teams who participated in the playoffs.
Indeed, my lord. Indeed, my lord. Because part of the relief sought is an interdict against the continuation of the playoffs. Pending finalization, they've got different versions of pending finalization of what. But on the one hand, for instance, Ravens are saying the playoffs must be halted until they get to play Amavarara and
until
the point
the
is
Eastern
there's a
Cape
lot.
sorts itself out.
The point is there's a lot in between.
Yeah.
And which, this is exactly what prompted, in accordance with the statutes, Safa to take the decision that it has taken. But we'll get to that if we get to the merits. So that is essentially the gist of the defense by Sinenkani. Ravens, on the other hand, are a special case. my lord. I think Ravens, and with the greatest of respect, I think the approach taken by Ravens is cynical. Ravens know that those parties ought to have been cited. That's why on their papers they create this fictional character called and South African Football Association playoff clubs. This fictional character is a cynical approach and an attempt to say, oh well, we knew that we must cite those clubs and we have. And my lord, I don't say this lightly that what they did was cynical, but it's demonstrated by their own papers. What they then do my lord, in their notice of motion in respect of these parties, they then say, it's at page 13, at the bottom of page 13, they list all the parties that are being served.
Page 13 of which
They-
you would
Ravens.
appreciate the difficulty.
Pardon me, my lord, page 13 of Ravens. Notice of motion.
Yes.
And then they say, my lord, so they list everyone that they are serving, we've got no issue with that. And then they say, and to South African Football Association, playoff teams, care of South African Football Association. So they just assumed upon themselves the authority to make Safa the post box for these teams. Because essentially what we are being told is, after the purported service of the papers on Safa care of these clubs, without asking anyone for that, Safa then, it's sort of like an instruction or a direction from Ravens FC to say, you now go serve them. And my lord, it would not have been difficult. I understand the pressures that practitioners face in urgent applications. We've all been there. But it would not have been difficult for FC Ravens to properly cite those parties and properly serve them.
You say they are in possession of this information.
Well, they know at the very least. Well, they ought to know, because factually I can't say whether they know or not. But they could have ascertained, or they ought to have inquired and ascertained who's participating in the playoffs.
Right at the outset, just highlighting something. When you started, you pointed out to me that the horse is almost at the gate. It's not yet bolted, it's not yet left the pen. But you said at 3 o'clock this afternoon, it's the semi-finals. Tomorrow, the finals will be played. Is it not one of those cases of extraordinary urgency? I'm just asking, I don't know. I've not read anything Ravens or Sinenkani has said. It's a case of someone you are told is in the shadow of death, it's on the verge of death. Papers are brought to you. Only the hospital is cited. The representative for the hospital stands up and says, it's not just us. We have independent doctors who are treating this patient, yes, in our premises, but they're not our employees. They are independent. I'm not saying it's the same thing. I'm just trying to draw an analogy that what the applicant wants to avoid happening is on the verge of happening, and the applicant brings what it believes is the principal role player before court. And the role player is now standing up and saying, yeah, I may be principal, but there are other role players.
My lord, this is the same these are the same applicants who've cited Amavara, whom I understand have not even participated in previous litigation.
They have, I'm sorry, for your benefit, they have been previously cited.
Well, I was specifically referring to the contempt. Well,
I understand your difficulty, Mr. Baba, so you were
yes.
not here.
My difficulty with the proposition, my lord, is that it's the same applicants who, for instance, are citing Amavara because they understand and appreciate that what we want from court is going to affect Amavara. Similarly, what they want from court is going to affect all those other parties in the manner that I've illustrated to your lordship. Therefore, those parties ought to have been cited. And in your earlier discussion with Mr. Scotty, something quite interesting came up because he took an instruction from his attorney, and I think what he got was the details of those parties were unknown. No, that could have been ascertained. As I said, firstly, one, you could ascertain who's playing, and two, you could then make the necessary plans to find out how to serve them. My lord, what Rule 12 allows is for the dispensing of rules when it comes to issues such as service, as we all know, and the manner of hearing of that matter. But Rule 612 does not go so far to say you can, because the matter is urgent, you can deliberately exclude someone who ought to be there from participating in those proceedings. It doesn't go that far.
You've condemned those Mr. Scotty represents, or to be specific, is instructing attorney. I'm sorry, I've read so much papers in these matters. I don't want to bring something that is not here. But the papers clearly say the South African Football Association and those you represent are responsible for the administration of football in this country. I take the point that these football clubs are independent legal persona. But if you've organized a tournament, they are participating in their own tournament at Safa. To serve these papers on Safa doesn't deserve condemnation. If anything, it indicates an earnest attempt to have those parties informed, because they know that you are in contact with these people. They are participating in your own tournament as Safa. That's how I'm looking at it. I may be wrong. Do you wish to comment on that?
My lord, I respectfully beg to differ with the proposition, because Safa's role is the administration of football in South Africa. Safa is not a post box. And I'm sorry, maybe I'm using harsh words, because let's accept that it was an earnest attempt. However, it did not go far enough, because Safa is not the sheriff. Safa is not a post box for these clubs. In fact, my lord, how would it look if Safa receives papers from FC Ravens and goes to the team from Mpumalanga and says, yeah, they are trying to stop the playoffs. Intervene, object. It smacks of collusion. It's not, Safa is not there to play that kind of role, and it would look bad and it would look collusive in nature. At the end of the day, and again, my lord, I say this understanding the difficulties faced by legal practitioners with matters of this nature. But at the end of the day, they were supposed to ensure that these proceedings are brought to the attention of all the relevant parties. My lord, I don't want to detain you with the test for joinder and all of that stuff and the law in relation to that. It's fairly clear, and you can take it that everyone understands it. I do want to make one final point, though, my lord, and it's on the question of appropriateness of the special plea or point of non-joinder. And it's now an accepted principle that my lord, that in our law, that the mere fact that a party may have an interest in the outcome of the litigation does not warrant a non-joinder plea. I'm reading a lot from Erasmus, the commentary to Rule 10, because this is just accepted law.
Yes.
If I were to tell you the cases cited on that point, would be here for the whole day. And then it goes on to say, the rule is that any person is a necessary party and should be joined if such person has a direct and substantial interest in any order the court might make, or if such an order cannot be sustained or carried into effect without prejudicing that party, unless the court is satisfied that he has waived that right to be joined. I just want to make the final point on that last sentence. So the court must ask itself, will the order sought by the two applicants prejudice these parties? If yes, then it was necessary for these parties to join. Unless the court is satisfied that he has waived that right to be joined. That's the case of Amavarara. Properly served, they've elected not to participate. So our point is not about Amavarara, but I'm just making the illustration that there could be circumstances where the court says, oh well, the order would adversely affect this person, but they've elected not to participate. The circumstances are different in relation to these 5 clubs. And if, for anything, it's demonstrated by the presence of Mr. Nslanti on behalf of Kakamas and Mr. Dlamini, who's here for claims. And for different reasons. One is here to say, I've played, I qualified to go to the no-cut rounds. One is saying, well, the effect of the decision is that where I was supposed to play 2 games, I'm only playing 1. So I make that point to say that, so there are reasons diametrically opposed, but I hear. Mr. Dlamini is saying, no, the decision of Safa is fine. Mr. Nslanti is saying,
I hear you. I hear you clearly. In an effort to save time, I don't want to ask you this when you are replying. You will agree with me that the legal point of non-joinder is not a fatal point when taken. It is merely a dilatory point of plea. Because a court did not dismiss an action or an application solely on this point, the worst thing that can happen for the plaintiff or the applicant is that the matter may be postponed, orders issued with respect to the service of those parties whom the court has determined have not been joined. Are you with me on that, or do you have different submissions?
Let me answer it this way. We will be satisfied with an order to that effect.
Yes, that is the usual order in the normal circumstances. In an application of this kind, an urgent application where a party is saying the court does not entertain this now, it may well be too late at any later date for the court to entertain this application. My understanding is that in practice, what the courts normally do, if the non-joinder point has merit, the court would issue a rule nisi. The court would then, as part of that rule nisi, say, parties A, B, C have not been joined. This is what the applicant needs to do to bring to the attention of party A, B, C that there is this application. This is what needs to be done before the return date. This is what those parties who have not been joined need to do if they wish to anticipate all the normal rights that are there. And then on the return date, those parties who've not been joined, or on the anticipated date, those parties that have not been joined are entitled to challenge the rule nisi as if it's the initial application. If, for argument's sake, one of those parties wish to challenge agency, which is not normally open on the return date to the parties that had argued, but the parties that have not been joined are entitled to argue agency, which they would have been entitled if they had been joined initially.
Yes.
All I'm raising with you, this is in an effort to save time, so that I don't raise this with you in reply. Mr. Scotty stands up and says, you had not raised this, we have not addressed you on this point, or any of the other legal representatives. May you address yourself to this, that even if I'm with you, that the other 5 parties who are not in this case ought to have been joined. I sustain your point, I uphold your point, but we proceed to the merits. And if the merits are in favor of your opponents, that is the applicant, if I were to issue an order, it can only be a rule nisi with a return date, because I accept your point that there are those 5 teams that ought to have been here but are not here, and they ought to get a bite at the cherry. I cannot issue a final order. What are your submissions?
My Lord, I accept that the court cannot make a final order.
Pardon?
I accept that the court cannot make a final order, because that would nullify any case that those additional parties would have wanted to advance. Where the order would be final, then
They can't participate anymore. They would have been denied the right to be heard
precisely,
if I'm with you on non-joinder.
precisely.
So you accept that.
I accept that the court cannot.
Best
make a
case
final
scenario for Safa is I'm bound to issue a rule nisi with a return date wherein those 5 teams in the national playoffs will get an opportunity to at least be heard.
to be heard and advance their own cases. Because
Yes.
as I've demonstrated or illustrated earlier on, we don't know what case they will make, because the 2 that have come came for different reasons, seeking different relief.
I may just say the 3 in Group A appear not to be affected by any of these. If they've proceeded to the semi-finals being played this afternoon, the prejudice is that they may just have to come back. Because the complaint here is that either FC Ravens or Sinenkani or Amavarara, I don't know, ought to have been in Group B. And if I understand Kakamas Juventus, they ought to have an extra team in Group C and play against that team. But
And in fact,
Group A, Mpumalanga, KwaZulu-Natal, and the Western Cape, it appears that group was proper. Of course, I don't know what has happened. It may well be that someone in that group who ought to have been the second best performing, or whatever the term you use, is affected.
So,
There are all sorts of improbables.
yes. But this being a review application,
Mm.
it's open to your lordship to craft an order of that nature.
Yeah.
172 allows the court to do that.
Yes.
Of Paja.
Paja
Is it
speaks of an
an-
equitable remedy.
So the point is, this being a review application, brought in terms of Paja, it's open for this court to craft an order of that nature.
Thank you.
That is the same. And one last thing, my lord, it's not just those 5 teams, it's also
The NSL.
the NSL.
Yeah, yeah.
As
The NSL is not yet affected at this stage. It's potentially going to be affected if whatever happens with Safa is not finalized to allow the NFD to kick off the league on the 21st of August, if I understand you correctly.
Indeed, my lord. And I don't want to cast any aspersions on any of the parties. But in respect of this matter, history has shown that we are dealing with parties who are prepared to seek to enforce their rights to the end.
Yes.
And that's an unfortunate or fortunate, that's a reality of the parties that are before this court. Everyone agrees that there's a long, long history of litigation based on substantially one match.
Yeah. No, I've heard you, Mr. Mabaso, unless there is something you have not yet said.
Those are my submissions, my lord.
Thank you.
As the court pleases.
Yes. Everyone else who's going to now participate, I must start with Mr. Vobi and then Mr. Dlamini. I understand you are co-applicants in 3011. Before I give anyone an opportunity, you've heard Mr. Mabaso. He maintains that there is non-joinder. I'm going to ask, looking at the time, I don't wish to get to the point where I have to limit parties in argument, but it looks like we're getting there. For the simple reason that I've been told the match is starting at 1500 hours. I don't want to be in the position Bloom J was in. You issue an order in the alternative because you don't know whether the match has started and been completed. You don't want to craft an order that is incapable of implementation because what you are addressing yourself to has already happened. So I'm going to ask that you be brief. Not that I'm trying to restrict anyone. Say the pertinent points you wish to say, but please be brief. It's essentially 2 things now. It's the non-joinder. You can indicate you agree, you disagree, the reasons for that. And as I've put to Mr. Mabaso, even if non-joinder is upheld, it appears to me that even if those circumstances prevail, a rule nisi will then have to be issued. Those 5 teams will be given an opportunity to be served. The order will specifically indicate how are they to be served together with the NSA. So I'm going to ask everyone who's going to address, confine yourselves to that. Let's try and save time. Please spare me having to put people to a restriction that you have so many minutes and I put a word here and say your time is expired, we'll move on to the next one. We'll start with Mr. Vobi for the first applicant in 3011 and then we will get to Mr. Dlamini for the second applicant.
I'm not for the second applicant, I'm for the 7th respondent. So maybe
Who is for the second applicant?
In 3011, my lord, it's Kakapos Mhlanti.
Oh, sorry, Mr. Mhlanti. Thank you for that, Mr. Dlamini.
I was saying, because I'm for the 7th respondent, can I start? Oh, okay, no problem.
You start addressing yourself to the point in limine. It's okay, you can
No, I was going to be brief. I think we're...
No, it's
yes.
fine, you can go ahead. You are for
the 7th...
Ikakamas student.
No. Things FC.
I'm sorry, it's quite a mess here.
My lord, I just wanted to address 2 aspects. I think we're in agreement on the basis that the application, if you are with us, on the question of non-joinder.
You've also taken this point.
I have taken that point on my, I can take the lordship there. on my bundle, the intervening party index,
Things FC.
Things FC.
Do you have heads of items?
Yes. But yes, I've got heads and I've got the index, 2 documents.
I'm sorry, man. I really am struggling here. I've tried to put the bundles separately, but it's not exactly helping. The proper thing for me to have done would have been to say I'm not starting this unless everything has been paginated and indexed, but it may defeat the purpose of the application. How many bundles do you have?
I've got 2 bundles. The one bundle, it says intervening party, then there's also the heads.
The heads.
Yes.
I'm sorry, I can't seem to. I'm going to have to ask for assistance from the registrar here. You may also assist the legislator. I'm looking for my heads. I can't seem to place a hand on them. Your heads are under what sheet?
They are written in the intervening party heads. That's what is written. But I won't take you there. I'm saying we can proceed just only if my lord has the intervening parties index. I'll just take you there.
Yes, I have that.
Yes. So I just want to take you to paginated page 15. Just to emphasize the point that paginated page 15, paragraph 32 at the bottom.
Yes.
Oh, in fact, paragraph 35, my lord. That's the other page at the bottom. We're sort of in agreement with what my
page 16.
Page 16 at the bottom, 35. Yeah. Okay. It says consequently the application should be dismissed, but we say or to be stayed until such time that all the provincial winners have been joined. So we're in agreement with that, and we've set it out in our papers. That's the one point that we wanted to. The other issue that we wanted to deal with.
Are you with me on the staying?
Yes.
That it's a dilatory plea.
Yes, that's what I'm saying. It's in fact mentioned in our papers.
And the proposal that I've made, that we get to the merits, if a case is made out, a ruleness is issued, but it can't be final, to give the parties that are not here an opportunity to be heard.
Yes, I think on that particular issue, we just wanted to address one issue.
Yeah.
In terms of the date regarding head to the ruleness. As much as my lord said the process might be at a later stage for the PSL to be affected, the fact of the matter is that the teams must be given to the National Soccer League by the 31st of July 2024 or in any year. So that date becomes...
You say there is a requirement.
Yes. to give the name of the teams to the National First Division or to the special member before the 22nd August kickoff.
Yes.
The last point, my Lord, that I want to address you on is on, if you look at our papers on service of the parties, if you look at the same document at the end, that is page 42, on the same document that we have, the last page.
Yes.
It says, I think I want to take you to 40.40. It says, any documentation of whatsoever nature which is required to be served on a team official or a player of the Safa League competition shall be served on such party either faxed or emailed as supplied by Safa, as supplied to Safa. So I just wanted us also to be alive to that fact, because I think the Ravens issue was the care of to all the teams. So in this specific, there's a rule which deals with the question of service. Those are the 7 respondent submissions.
So because Safa is here, do I understand you to say Safa may be requested to provide the email address for the 5 teams and the NSL, and they ought to be served on that if I am persuaded to issue a ruling?
A ruling, that's what I'm saying.
Thank you.
That's my submission.
Thank you, Mr. Lama. Yes, Mr. Bobby.
As a copy, I'm not sure whether should I proceed. That was just a request that my learned friend was proposing, I think in view of what the applicants might argue, and in consideration of the time as well, that maybe we get a short adjournment. I think the purpose of that is to discuss the topics, because on this issue at least we can agree that we're on the same side. It won't be important that I make my points, then when Mr. Scotty is arguing, he also repeat what I've said, but if we separate topics, I take certain topics, then he takes certain topics, because I think the court had also indicated that we can also deal with the merits, and then in respect of whether the point of non-joinder as merits or not, we come with our suggestions in view of the order that might be granted in the event we succeed.
We have the sword hanging over these proceedings. It's now 14:15. What are you proposing about the discussion, the length of the adjournment? That's what I need your input on.
We can get 5 minutes.
We reconvene at 14:20. Court will adjourn until 14:20. Yes, Mr. Bobby.
As a conclusion, we had a discussion as parties, as applicants. We are proposing an approach in view of the engagement that the court had with our learned friend for the respondents. We are proposing an interim order to be taken for the parties to come to court, let's say on Tuesday, to one, to the effect that they must come and justify why the decision that has been taken should not be set aside. And two,
Sorry, Mr. Bobby, before you go further, I just want to be clear. Are you saying the Safa respondents are agreeable to what you are proposing?
my lord, I'm saying as applicants, this is what we propose.
Oh.
Yes. And the reason we are coming with this proposition, it is because of the point of non-joinder that they have raised. Because we don't want to appear like what they did to us, where in a closer phrase, one will say, so we want everyone to be given a fair opportunity as they argue. Then we come on Tuesday, then we deal with all the issues.
I will accept that, Mr. Bobby, as relating to the non-joiners. But with respect to the merits of the application, you each would still have to address me, why should this application be granted? Unless the Safa respondents are saying they concede that a rule DC must be issued. Do you understand the position I'm in?
Malak, the reason we are proposing this, because I think if we can all understand, which is something that, because I think if we can all understand, which is something that Safa respondents have been trying to avoid by all means, the interdict, which is as a consequence of setting aside the decision. But the decision that is in question, they have not made any submission insofar whether is it linked to the non-joiner point that they're taking about.
No, I'll come to Mr. Mabaso's defense. I have restricted Mr. Mabaso to address me on 2 points. First, I said address me on jurisdiction, which he did. I then said I've made a ruling on jurisdiction, I can now enter the matter. Address me on non-joiner. That's what he did. I had said to you and everyone else, address me on non-joiner so that we can get to the merits of it. But as I understand what you say, the applicants do not even wish to spend time addressing me on non-joiner. They accept the point that a rule NISI may be issued with a return date so that the non-joiner point may be addressed, which is a point Mr. Mabaso had considered himself, that if there is a rule NISI, then it takes care of the non-joiner point immediately. In which case, Mr. Dlamini has addressed me, Mr. Mhlandi is for an applicant, and Mr. Scotty. You say the 3 of you have discussed it, in which case all that will be before me will be what rule NISI should I consider, has the case been made, and that sort of thing. Unless Mr. Mabaso is prepared to make a concession that at least, I think he said, his colleague is going to address me on that. Or between the 2 of them, let me put it that way. Unless the Safa representatives make one or other concession, I can't just sitting here, Mr. Vobi, please understand my position, say, a rule list will issue. Because even if you were to all agree that a case for the issue of a rule list has been made, I'm going to ask that we meet in chambers. That arises from my personal experience. Mr. Mabaso and Mr. Mhlanti, Mr. Dlamini may not be aware of it, but I've issued an order in terms of a review on Tuesday last week. An order that speaks, don't want to say with both sides of my mouth, because this is a football issue. I had issued an order which I thought is appropriate. Then the arguments in court came to my mind that no, there is a forfeiture of points. To football people it means this. I thought, yeah, let me cover the forfeiture also. You see, if I were to provide you with my judgment, you would see how I got there and what is meant by that order. So I am not going to repeat that mistake now. Even if we agree a rule NISI, we have to have a discussion so that you obtain instructions from those who've instructed you on a rule NISI with this effect. What is an appropriate order from a football perspective? I would do the same if this was a fishing matter. I wouldn't just issue a rule NISI not knowing what effect it would have on the fishing enterprise, if you get my drift. Sorry, just bear with me. Let me propose this. We can go and discuss it in chambers now, but I don't want to discuss merits in chambers. We will only go to chambers once we have an understanding. I've heard you all, I've made up my mind, this is the order I'm going to issue, then we can go to chamber. But if there is some sort of agreement you have, even on limited points, then we can go to chambers. Mr. Mabaso, I take it you are the lead concern. I don't know whether you are going to address me on this or Mr. Vilakazi is addressing me.
My Lord, the submission by Mr. Gobi has it's come up at us. We were not expecting it, so we would at the very least need an opportunity to first discuss the proposal with our learned friends,
Yes.
and then take an instruction, and then we can approach the worship in chambers to discuss the situation. But I don't have an instruction. I'll have to discuss the matter with my attorney, then client, and so forth.
No, that's perfectly acceptable and understandable. How much time are we talking about? You would recall we are working to a deadline.
10 minutes.
10 minutes.
If I may suggest, it will probably now be 13 minutes.
No, it's fine.
make it
We
13,
can
15.
reconvene at 14:50. Mr. Mabaso and Mr. Vilakazi, would you ascertain from those who are at the grounds where the playoffs are happening, because the playoffs are happening at your behest? You are the association that is organizing them.
My Lord,
Inform, be it Advocate Motlante or anyone else, or the competition committee, the relevant people you would know, they are your clients, that this is now happening. I do not expect that they will go ahead as if nothing is happening. Even if they put proposed deadline to the court to say, may we get an indication by this or that time. But as officers of the court, you would know what it means for one of the parties in court to be proceeding outside court as if nothing is happening in court. I had wanted this not to happen, that we get an indication before the match starts. But the match cannot go ahead as scheduled in circumstances where we are now in court and discussing that match.
My lord,
This is why I'm saying, if they say to you, cannot be here later than, we cannot start with the match later than this time, it's something that everyone here is going to take account of. But it's not a matter that is within the sole preserve of Safa now. I appreciate the responsibilities. It's in these papers, I've also been told before, the responsibility and the heavy responsibility that is on Safa's shoulders with regard to see to it that there is progress in these matters. I am not saying they should all cancel it and go home and wait for the court to pronounce. But all I'm saying is, in these circumstances, I expect them to show deference to the court, to say we were supposed to start at 3, we're showing respect to the court process, we will wait until this time. These exigencies make us not to wait beyond this time. We will take that into account.
you will discuss it with client, my lord. As I understand it, just at the moment when we were called back into court, client had contacted Mr. Sinenkani to say the SAPC has arrived, what is happening, and I don't think Mr. Sinenkani has had an opportunity to discuss that because we couldn't make it, but we certainly have the conversation with the client. As I understand it, the first semi-final was scheduled to start at 3 p.m. and the second one was scheduled to start at 6.
That tells me already that the matches can start at 6. I know
this is why I mentioned it.
there is television rights, sponsorship, and all of that, and schedules have been arranged, but this is not a secret. It's being published by the media in court. People in the viewers and everyone else can be told that there is a delay because we are here. All I ask is discuss this also with your opponents. We must take into account everyone's interest.
Indeed, my lord, that's why I
Yes.
suggested
Look,
given an opportunity to provide.
the exact time is 14:50, but even if we start at 14:55, I'm not going to take issue. All I say is I expect Safa to see to it that due difference is shown to the court.
Given the discussion my attorney will have to have with client, might I suggest that we just round it off and come back at 3?
3 o'clock is fine.
As the court
As long as the match really has not finished, because even if they want to honor their sponsorship agreement and whatever else, if I pronounce at 15:30 for argument's sake, that an interim order has been issued, then they would have to cut off the match at that point. I don't understand that they can defy the court, even if they get it at halftime, that there is this order and then they say, we are going to ignore the court and continue with the match. I don't think that would be proper. But you are trained legal representatives, I'm not going to tell you what to tell your clients. You know exactly what to tell them.
My lord, client will be advised accordingly.
Court will adjourn until 1500.